Good morning, Committee Secretary. Can I check whether we meet the quorum?
Good morning, Chairperson and everyone on the platform. Chair, we're correct. Shall I do the roll call? Chair?
Recording in progress.
Proceed.
Mr. Mumbayani?
Good morning, Chairperson. Good morning, colleagues. I'm present. Thank you very much.
Morning.
Dr. Luntwane? Chair is on the platform.
Yeah, I see it.
Ms. Muatse?
Good morning, Chairperson, and good morning, everyone. I'm present.
Good morning.
Mr. Mulder?
Good morning, Chair. Good morning, all. I'm present.
Good morning.
Ms. Honiana?
Good morning, Chair. Good morning, everybody. I'm present.
Good morning.
Mr. Three?
Morning, Chair. Morning, colleagues.
Morning.
Mr. Malamatia?
Morning, Chair. Morning, colleagues. I'm present. Thank you.
Morning.
Chair, those are all members currently on the platform. The others may join us, and I'll keep you posted on that, Chair. Thanks.
Thank you. Can we see the agenda for today, please? Here we have the adoption of the agenda. May I request members to indicate whether they adopt the agenda for today as shared, yeah.
Mr. Mumbayani, Chair?
Honorable Mbayani.
Chairperson, thank you. I propose that we adopt the agenda as reflected. Thank you.
Thank you. And Honorable Moate.
Thank you very much, Chairperson. I second the move of the agenda.
Thank you. And then finally, can I check whether there are any apologies, Committee Secretary?
Chair has indicated I have not received any formal apologies, but I will inform you if I do, Chair. Thanks.
Okay. But we are quoted. We can proceed.
Correct, Chair. We can.
Thank you very much. Welcome to everyone, all stakeholders on the platform here today, joining the Portfolio Committee of Trade, Industry and Competition. The Companies Amendment Bill and the Companies Second Amendment Bill was introduced in September 23 in Parliament and referred to the Portfolio Committee for Trade, Industry and Competition for its consideration and report. In order to facilitate public participation in the legislative process as required by law, the committee has placed adverts in print and social media calling for public comment on both bills. The committee received 41 substantive submissions, as well as smaller submissions from the public in this regard. Public hearings on the above-mentioned bills have been scheduled over 3 days. Therefore, the purpose of today's meeting, which is day 2, is to receive oral submissions from stakeholders identified by the committee. As public hearings are held on the virtual platform, it becomes important that stakeholders comply with the requests communicated by the committee secretary. 1, all parliamentary rules in relation to hearings apply. The chat room is for the use of members, staff of Parliament and departmental officials only. Failure to comply may result in the removal from the platform. 3, each stakeholder will have 15 minutes to make their presentation, followed by a 20-minute engagement. 4, stakeholders are reminded to switch on their videos when they present, if they are able to do so. When you have completed your submission, you are free to leave the platform if you need to. You are also welcome to stay for the duration of the meeting. So we will now proceed with our public hearings for day 2. And we'll start with the Banking Association of South Africa and Ms. Musumba, Ms. Haystack, and Mr. Chetty from the Banking Association of South Africa. Over to you. You may share your presentation and proceed.
Good morning, Madam Chair. Please allow us a second to share our presentation. Kindly confirm if the presentation is on.
We don't see your presentation, though. Who's sharing the presentation? We see your beautiful faces.
I am sharing it.
Okay.
Give it a moment.
But we don't see it yet. Okay. There we go. You're starting to share now.
Okay, perfect.
Proceed.
Thank you, Madam Chair. Good morning, Honorable Chair and members of the committee. The Banking Association of South Africa would like to thank you for the opportunity to participate in the public hearing process in respect of the company's First and Second Amendment Bill. The members of our BASA team this morning are myself, Ms. Nelia Musamba, Ms. Elsa B. Haystack, and Ms. Maliga Chetty. Who is BASA? BASA advances the interests of the banking industry with its regulators, legislators, stakeholders to make banking sustainable, profitable, and better able to contribute to socio-economic development and transformation of South Africa. As the National Association for 32 domestic and international banks operating in the country, BASA advocates the views of the banks on legislation, regulation, and socio-economic issues that affect and impact the industry and financial stability in South Africa.
Can I just check, Ms. Musamba, whether you have moved to the second slide? Because we still see your cover slide.
Oh, there you go.
There we go. Thank you.
That was our introduction. Apologies, Madam Chair. We are now on slide 3. As a point of departure, BASA supports the objectives for legislative reform, which will facilitate the ease of doing business in South Africa. We wish to express appreciation for the revised bill, and we confirm our support of the proposed amendments in the Second Amendment Bill, and we have no comments thereto. BASA has submitted a detailed written submission in respect of the bill to the Portfolio Committee, and notes that a lot of our comments have been addressed, a lot of comments raised by industry and business in previous drafts. We support the measures to enhance the ease of doing business in South Africa and issues raised by the industry and business in previous drafts. Our presentation today, as you will see, focuses specifically on 2 of the proposed amendments to Section 30 capital A, specifically subsection 6 and subsection 9. I will hand over to my colleague, Ms. Elsa B. Haystack, who will take us through the presentation and the BASA concerns in much greater detail. Thank you, Madam Chair.
Thank you very much. Ms. Haystack.
Good morning, Madam Chair and honourable members of the Portfolio Committee. As indicated by my colleague, Ms. Musamba, we bring to your attention 2 of the more material issues of concern to the banking industry due to their potential adverse impact on investor confidence in South Africa, sound corporate governance practices, and the stability of leadership teams and boards of public companies. Before we address our concerns, and at the outset, it is important to acknowledge Parliament's drive to address matters raised by Labour. We support the proposed disclosures of remuneration of directors and prescribed officers, the pay gaps and the other requirements as are now or would be required in terms of Section 30 A sub 3. In this regard, we confirm that BASA members have been disclosing remuneration of directors and prescribed officers in their annual financial statements and in their integrated reports over many years, as required in terms of the existing provisions of Section 30 of the Act. These documents are already accessible to the public. Moreover, as an industry, we do not have an issue with the proposed binding vote on the remuneration policy in respect of directors and prescribed officers in terms of the new Section 30 capital A sub 1 and 2. We now turn to the matters of concern, which are included in the draft clause 6 of the Companies Amendment Bill as a new proposed Section 30 capital A. And then the first issue is the proposed required binding vote by shareholders at the AGM on the implementation report. The Section 30 capital A sub 6 provides inter alia that the remuneration policy and the implementation report must be approved by ordinary resolution as two separate documents. BAS's reasons for concern with the proposed binding vote on the implementation report are summarized as follows. In our view, this may create practical and labor challenges, as what will be required is in essence retrospective or after the fact voting by shareholders on the implementation of payment of remuneration to directors and prescribed officers in respect of the 12 months preceding the AGM, where the implementation report will be put to vote. The vote by the shareholders on the implementation report therefore occurs after remuneration and benefits such as salary increases, short-term and long-term incentives have been paid or awarded to directors in terms of such previously approved remuneration policy. In essence, the vote on the implementation report, whether binding or not binding, cannot impact the outcome which was already implemented in the preceding 12 months. In practice, the implementation report is based on and explains how the principles set out in the remuneration policy, which had been approved by shareholders at the previous year's AGM, were implemented and executed on by the company. It is very unlikely that a public or listed company would, in its execution practices, deviate from the principles approved in the remuneration policy by shareholders at a prior AGM, as this would make for poor corporate governance. Finally, and significantly to note, it is our understanding that South Africa's requirements in this regard could be the first country to enforce in this regard would be out of line with those of the other jurisdictions globally, and we could be the first country to enforce a binding vote on the implementation report for listed companies, with the proposed immediate consequence of RemCo members having to step down. This would result in...
Can you move your slides, please? Because we're still on the slide ending with South Africa.
We're still on that slide, but we can...
Oh, you are? Okay.
Yeah.
My apologies.
So this would having more stringent remuneration corporate governance practices compared to other jurisdictions, which may hinder business development and investment growth and confidence in South Africa. This could furthermore result in the purposes set out in Section 7 of the Companies Act, like the promotion of innovation and investment in South African markets, using the company as a vehicle to achieve economic and social benefits and to enhance the economic welfare of South Africa's partner within the global economy not being achieved. BASA therefore recommends that approval of the implementation report continue to be by way of a non-binding advisory vote as per the current requirements under the King IV recommendations and the JSE listings requirements, as opposed to the proposed binding vote. It is our respectful view that the current practice that has been in operation for many years in terms whereof companies obtain a non-binding advisory vote on the implementation report at the AGM has been working well. It has led to constructive engagement by listed companies with key shareholders ahead of the AGMs and thereafter, due to the important message conveyed to the market had the non-binding vote not been passed, noting that the results of AGM outcomes of listed companies have always been in the public domain. So moving to the second concern. So our second concern, we wish to highlight is the proposed amendment set out in Section 30 capital A sub 9, which contemplates that in the event of the non-approval of the implementation report at the AGM, the non-executive directors or NEDs who serve on the Remuneration Committee or REMCO must immediately cease to be members of the REMCO and will not be eligible to serve on the REMCO for a period of 3 years post the AGM. The reasons for BASA's concern with this proposal are summarized as follows. And Madam Chair, we apologize. We've moved some of our reasons and shifted them. So what I am going to present is then presented in the next 2 slides, maybe in a different sequence.
That's fine. Thank you.
The proposed amendment imposes harsh consequences on NEDs serving as members of REMCOs and does not afford them an opportunity to explain the content of the implementation report and to address the concerns of shareholders by engaging with the shareholders themselves. They are the ones with the intimate knowledge of discussions at REMCO meetings and why matters have been implemented as reported. Yet they may not have the opportunity to engage with the shareholders post the AGM. It will be difficult for new REMCO members to engage with full knowledge of all events when engaging dissenting shareholders on the implementation report prepared by previous members. Practically, the immediate stepping down of REMCO members contributes to increased risk in respect of board membership and composition. It is a known fact that we have skills, competencies, and depth shortages in South Africa. The already small pool of directors with requisite knowledge, prepared and skilled to serve on REMCOs may reduce further. The proposed amendment may create challenges for companies to attract and retain appropriately skilled directors to serve on REMCOs, where very specialized and specific skills are required to address the dynamic and ever-evolving labor landscape and balancing the requirements of companies and employees alike. Moreover, the timeline proposed for being ineligible to serve on the REMCO for 3 years is problematic, given the scarcity of suitable skills mentioned already. It will sterilize participation of knowledgeable individuals on REMCOs for a significant period. It might also result in an NED not being eligible to serve on a REMCO of one company, but being able to serve on a REMCO of another company whose implementation report was passed at an AGM. Potential board member candidates may not wish to serve on REMCOs due to the perceived personal reputational risk, adding to the shortage of skills issue. It is critical to note that presently shareholders of listed companies have powerful rights and protections through existing mechanisms provided in the JSE listings requirements. These existing mechanisms go far beyond the requirements of Section 66(4) of the Companies Act, which require that only 50% of board members must be appointed or elected through shareholder votes. In terms of JSE's listings requirements, all board members are elected by shareholders through votes at the AGM. There's also a stipulation that 1/3 of non-executive directors are required to stand down for election by shareholders at each AGM. Shareholders therefore already have the ability to indirectly determine the composition of REMCO as they come up for re-election in this prescribed process. The stand-down of REMCO members after one strike as proposed in the bill may therefore not be necessary at all due to the existing regulation. The one-strike approach as proposed in the bill, meaning immediate ineligibility after one failed vote on the implementation report, it is extremely onerous compared to other jurisdictions. Some jurisdictions, such as Australia, follows two-strike approach, which ensures that companies engage with shareholders after the first failed vote in order to address their concerns and to avoid a second strike with more serious consequences. The immediate stepping down of the REMCO members could introduce significant disruption, uncertainty, and risk to the ongoing good corporate governance of the company and the stability of the board. Each time the REMCO is reconstituted, the other board committees would most likely need to be reconstituted as well. The ineligibility of REMCO members may over time lead to increases in the size of boards, an undesirable consequence, as it could negatively impact on the cost of governance and cause other inefficiencies. As we represent the banking industry, we need to specifically refer to Section 64C of the Banks Act that requires that the REMCO of a bank shall consist only of non-executive directors. We note that all appointees to bank boards must first be approved by the Prudential Authority, or PA, prior to their appointment. It may therefore be particularly burdensome for banks to comply with the requirements of the Prudential Authority in finding suitably skilled, fit and proper non-executive directors to fill vacancies created by the proposed immediate stepping down of REMCO members, especially if additional board members are to be appointed. To avoid the risks and concerns highlighted, BASA respectfully proposes as a preferred option that the requirement that REMCO members shall not be eligible to serve on REMCO for a period of 3 years be removed from the final version of the bill. The NEDs of REMCO should therefore not become ineligible to serve on REMCO as a consequence of the non-approval of the implementation report after the first strike or non-approval. We propose as a replacement provision, and in the interest of meaningful engagement with dissenting shareholders and expedient addressing of their concerns, that dissenting shareholders be obliged in terms of the Companies Act to participate in engagement with the company in a constructive manner. Our proposal is that a requirement be included in Section 30A, providing for an obligation on shareholders that voted against the approval of the implementation report to disclose the reasons for their objection and writing within a reasonable period after the AGM. In our view, shareholders should be obliged to have relevant and substantive reasons for voting against an implementation report. And in addition, a requirement for the REMCO members who were involved in the preparation of the implementation report and execution of remuneration policy to engage with dissenting shareholders that have disclosed their vote and the reasons therefore, and to address their concerns in subsequent policies and reports. In the alternative, if the bill is passed as is, BASA recommends that the REMCO NEDs would only become ineligible if the implementation report is not approved for 2 consecutive years, thus after the second strike. In addition, that such REMCO members should be ineligible for a period of 1 year only, rather than the proposed 3 years. BASA members are respectfully of the view that the same results that the Parliamentary Committee aims to achieve with the draft provisions to Section 30A sub 6 and 9 could be achieved if the proposed amendments by BASA are taken on board, as the BASA proposal support meaningful and constructive engagement with shareholders where there is dissent with the implementation of remuneration policies. The alternatives proposed by BASA may be easier for the company to implement. They will not add to the scarcity of skills risk in South Africa, and they will contribute to the South African regime being aligned with global best practices. We respectfully submit that this will complement the rationale for making proposed changes to the Companies Act in the interest of ease of doing business in South Africa and globally. Moreover, our proposals acknowledge and recognize the existing powerful rights of shareholders already in operation for listed companies in South Africa. I thank you for your time to engage and listen to our views, and ask my colleague, Ms. Nelia Msumba, to wrap up the formal presentation for us. Thank you.
Thank you.
Madam Chair, thank you. Whilst we only focused on the material matters during this presentation, we humbly request that you kindly consider our other comments as well as per our written submission. Thank you, Madam Chair and members of the committee for allowing us to present. This concludes our presentation as BASA. Thank you, Chair.
Thank you very much for this presentation. I now open the floor to members of the Portfolio Committee to interact with your presentations. Members, you may indicate with a show of hands. Okay, Honorable Mbuyane.
Thank you very much, Chair, for the opportunity. Chair, mine is just a clarity-seeking question. Let me first welcome the presentation by PASA, and it's also giving us more of a clarity in terms of the information. Just that I wanted to check the investor confidence they spoke about, and also the hindering of development of growth by this section 3A, subsection 6. And also they propose that 9 binding advisory vote as per the current requirement is feasible. Also, they've indicated that there's a harshly consequence on non-executive director serving as a member of the remuneration committee. So I want more clarity on that. What are those consequences of those numbers, and also the contribution in the increase of the risk in respect of board members. Let me pause there for now. Thank you very much for the opportunity, Chair.
Thank you, Honorable Mbuyane. Honorable Malamacha.
Thank you, Chair. Mine is on the first concern. I want to rest about that there's absolutely nothing wrong for the country to be innovative in whatever legislation that thinks it can assist itself, and also be a new way for all other countries so that they join. So if as the country will be time and again have a fear that if we come with this kind of amendment, then it will be wrong, not necessarily be wrong. It's something new to other countries that it never happened, as if other countries are not doing the same. But I also want to welcome their recommendations, bearing in mind that their recommendation must be complementary to what we are trying to do, in a sense that there was nothing, now we're putting something on the table we will still achieve, because it sounds surely that they are also positive to say we will achieve the objective of this amendment. So they must remain cool and supportive. I don't think there's much except to say I wanted to deal with that concern. Thank you, Chair.
Thank you very much, Honorable Malamacha. Honorable Dr. Ntwani.
Good morning, Chair. Good morning, committee members. I want to thank and welcome the presentation made by PASA, Chair. And I think mine would be more in line with regard to a comment, just to say that indeed South Africa has always been first in innovativeness in terms of legal issues. And I think the innovation in the amendment with regard to Section 3A and Section 9 is part of the innovation that we would want to bring in with regard to the companies law. But I also recognize and acknowledge the fact that as board members, the risk of reputation becomes critical when you have to resign after a particular issue has happened, and it's very difficult to get into or onto a board after having been challenged or your reputation being challenged. But also I want to recommend I want to recommend PASA for the recommendations that they have made. It's very enlightening and it's very progressive, and I want to thank them for that. Thank you, Chair.
Thank you very much, Dr. Ntwani. Honorable Thring.
Thank you, Chair. Chair, mine is just a fairly simple question. I think that we've heard some of these concerns also from, JSE, from SAICA, the concerns also from the Law Society with regards to these particular sections raised by BASA, which is section 30A subsection 6 and 30A subsection 9, with regards to the binding vote on the implementation report, and that if this implementation report is rejected, the effect that it actually has on your non-executive directors. Now, my question would be, there are obviously those who feel that the recommendations within the your recommendations, as opposed to what is currently in the bill, on a scale of 1 to 10, would you feel that these the drafts within the bill would be, how onerous would it be, and how damaging would it be to the economy if it were kept the way it is? And are you able to further substantiate why you are actually making these recommendations in terms of section 30A6 and 30A subsection 9? Thank you, Chair.
Thank you. Thank you very much, Honorable Thring. Team BASA, over to you for responses.
Good morning, Madam Chair, and good morning, members. Madam Chair, there's been a lot of overlap in terms of the questions. So what I'll do is I'll address them, taking the overlap into account. And then if we have missed anything, my colleagues will either fill, or if the members don't mind, they can just remind us and we'll continue to respond.
Fine. Thank you.
Thank you. So in terms of the investor confidence, and my colleague has spoken a lot about it, is that if the implementation report is rejected, there will be perceived governance issues at a company level. So that's particularly where the investor confidence comes into play. So I'm going to just speak a little bit about it, but what I would like to do is take the members through the example that was included at the end of the BASA submission, because I think that explains a lot of the queries. The second comment on, and maybe that goes to the last question in terms of, on a scale of 1 to 10, what is the damaging effect of a binding vote? So I think that first and foremost, and this was already alerted to, is that if it is a binding vote on the implementation report, we need to take into account that the implementation has already taken place in the prior 12 months. And that's the point that we've made about the potential labor challenges. So for instance, if directors and prescribed officers have been paid a certain amount for remuneration, which would include your incentives, short-term, long-term incentives, and if now the implementation report has been voted against, we need to find a mechanism to go back and either correct the payments that were made, and that's where the labor challenges would come into effect. So on a scale of 1 to 10, I think if you're looking at a number of labor law challenges, I would rate it almost on a 8 to 9 out of 10 in terms of the issues going forward. Madam Chair, if I could possibly take the members through Annex A, which is the illustrative example at the end of the BASA submission. So working on the assumption that Section 30A with all of its subsections comes into effect in 2023. In 2024, at the AGM, the remuneration policy will be approved by shareholders and its validity will be for 3 years until 2027. And then so remuneration report approved in 2024, that means the implementation will take place during that financial year, and the implementation report will be tabled at the AGM in 2025. If the implementation report is not approved in 2025, some of the consequences, the immediate consequence is that, working on the assumption that you have a board of 12 members and 4 of them serve on the REMCO,
4 members would immediately of the REMCO have to step down, and they would need to step down for a period of 3 years, which will be until 2028. The other impact is that, as I've explained, all of the payments that were made to the directors and the prescribed officers in the prior 12 months would need to be reversed, and that would result in the labor challenges. With the REMCOM members having to step down, the other boards would have to be reconstituted to either accommodate the REMCOM members on other committees, and then find some of the other committee members to then serve on REMCOM. So, and then as my colleague mentioned, there are also potential approvals that we would need to obtain from the Prudential Authority. If we look at the second year in 2026, and if the implementation report is not approved again, that means the other 4 members of the board who now served on the REMCOM will have to step down. And then again, the board committee is reconstituted. And then in 2027, if you're working with 9 non-executive directors, you will only have one non-executive director to serve on the REMCOM. So that is just the long-term impact of members stepping down and the consequences. In terms of the reputational risk and directors having to resign, one of our honorable members already made the point that the reputational risk is members resigning, and that will be a stigma attached to them for the rest of their directorships on other boards. You will also be in possibly in a very precarious position, if I can call it, where that member who has to step down on the REMCOM of the board of one listed entity will still continue to be a REMCOM member, or even the chairperson of the listed company, another listed company, where the implementation report was not voted against. So the precarious position is that vote of no confidence in one company, but still continuing as chair of a REMCOM in another listed company. I think I've dealt with quite a few of the questions. I don't know if my colleagues would like to add anything, or if the members would like to remind us if we haven't touched anything or responded to some of their questions. Thank you, Madam Chair. Thank you, members.
Thank you very much, Ms. Haystack. You feel that you're sufficiently covered?
Thank you, Madam Chair. I think we are sufficiently covered because these questions did overlap, and obviously the consequence of, on the boards and the disruption and also be out of line. I think maybe we can acknowledge the fact that in South Africa, we often the leader with legislative change, and it's a good thing, and we acknowledge that and the innovation, but maybe this is not the one where we should lead in the interest of the board and good corporate governance and stability. Thank you.
Madam Chair, sorry, if I may just add to that. So I totally agree, it's good and progressive for South Africa to always lead, but we can achieve the same outcomes with a non-binding advisory vote rather than a binding vote, which will have the adverse consequences, but will have the same outcomes with the non-binding advisory vote and the opportunity to engage with dissenting shareholders. Thank you.
Thank you very much. Can I just check with Ms. Musamba whether she has any concluding remarks? We still have 2 minutes.
Thank you, Madam Chair. No, nothing from my side to conclude. My colleagues have covered all the questions. That concludes it from our side.
Thank you. Thank you so much, Banking Association of South Africa. Well represented. Thank you very much. We'll now move on to the next presentation, and the next presentation is from Sasol, and we welcome Ms. Hubert and Ms. Nienaber to the platform to make your presentation. Thank you.
Thank you, Honourable Chair and committee members. I'm going to share my screen. Just let me know if you can see it. It's Elaine speaking.
Okay, we don't see it yet.
Okay.
Okay, I see you have sharing rights now. There we go. If you can just put it in slide mode.
There you go. Can everybody see?
Yes, yes, thank you so much.
Thank you for this opportunity. Just to highlight some of our main comments. Firstly, we just want to point out that in general, SASOL supports the proposed amendments in the draft Companies Amendment Bill and Second Amendment Bill. One of the aspects I'd just like to highlight is that in section 16(9)(b), with regards to amending the Memorandum of Incorporation, currently the proposed amendment talks about the receipt of notice by the Commission. However, we propose that the word filing is used instead of receipt, considering that filing is defined in the Companies Act at present and not receipt. We think that it's going to be difficult to prove that the document or the MOI has been received by the Commission, seeing that they do not stamp any documents that's physically submitted at the moment, and also there's no return emails, practically speaking, from them when you file your MOI. So that is in relation to section 16. I'm going to hand over to Renelle just to talk about section 30A.
Good morning to the Honourable Chairperson as well as the members of the Portfolio Committee, and thank you very much for the opportunity this morning to address you with our concerns. SASOL has previously provided more elaborate, an elaborate submission with regard to the proposed amendments, but for purposes of this hearing, we have really focused on the matters which we believe will have some dire consequences for boards and also not necessarily serve in the best interest of corporate governance, which we believe this particular statute should be aiming for. With regard to my comments on section 30A, and that is where I'll be focusing on, we would just like to start off by confirming that from a SASOL perspective, we support a well-governed, effective remuneration system in South Africa that promotes fair, responsible and performance-driven remuneration for all employees, and a living wage for the most vulnerable employees in our society. That in fact then should foster job creation, economic growth and a sustainable economy. To reduce inequality, which is an absolutely untenable situation in our country. We do believe, however, that the various causes thereof, including discrimination across all fronts, unequal access to the economy, high levels of unemployment, low levels of skills, poor quality education, to mention but a few, should holistically be addressed. And therefore that matters, like for example, the emphasis on pay gap reporting would not necessarily address inequality in isolation. We also believe that, and this is without trying to sound defensive, but that to an extent executive remuneration has globally become a bit of a poster child for inequality in the global economic order and also disorder and discourse of the day. No country in the world has proven that through greater emphasis on public disclosure of pay information, the pay gap has effectively been reduced. And in fact, quite to the contrary, if you look at executive pay and pay gaps over the last 20 years, that has just significantly increased, and to such an extent that in fact it is no longer acceptable, I think, in any country in the world. Executive pay disclosure has been a requirement for listed organizations in South Africa since 2008, and even such disclosure has not negatively impacted the growth thereof, and neither has it positively impacted the pay gap. On the next slide, Joe, so we have extracted three particular areas which we would like to bring to the committee's attention for their respectful consideration. And the first instance under section 38(2), and that is specifically just to recommend for a more orderly transition period from the current dispensation to the new dispensation, should that then be implemented. That the remuneration policy as contemplated in subsection 1 must be presented for approval within 12 months after the effective date. So at the moment, the proposed amendments are silent in terms of the effective date thereof, and potentially this particular transition period could be addressed elsewhere, but that would just be our recommendation to ensure an orderly and aligned transition period. The two broader matters which we would like to elaborate on a little bit more relates to section 30A(3)(f). in terms of more meaningful disclosure. Chair, we did in our previous submission highlight the fact that we do not believe that the recommended methodology necessarily would change the pay gaps in the country. Would it necessarily address the rationale of inequality? However, that's fine. So pay gap reporting is not new to South Africa because already through Form EEA4 under the Employment Equity Act number 55 in South Africa, employers who employ more than 50 employees have to disclose their pay gap information. And in fact, what we would like to recommend to the committee for consideration is that the same methodology be followed of what is currently included in Form EEA4, and the two very specific matters that we would like to bring to your attention, Chair, is the inclusion of full-time permanent employees. So by including, for example, half-time employees or expatriates in our country would not necessarily give you the right nor the consistent disclosure that would be meaningful in terms of tracking, because we do believe that tracking the pay gap is obviously the rationale for this particular pay disclosure, and by in the first instance not fixing the cohort that will be included, we believe that you will then find significant distortions year on year in terms of such disclosure through the inclusion of, for example, half-day workers or non-permanent employees or expatriates, etc. In the second instance, what we believe is really important through Form EEA4 is that there is additional reporting which is required on specific cohorts from a race, gender, and people with disabilities perspective. And by including this, not only do we broaden the net, we put the spotlight on these groups of people, but we also ensure that those people who are the most vulnerable in our society in fact, also get included in the net, and we force companies, therefore, to also make sure that they implement the required mechanism to address not only the vertical pay gap, which we do not believe will be addressed in any event through this disclosure, but more importantly, the horizontal pay gap. In other words, people who are employed in a particular occupational level in the organization, that from a race and a gender perspective and a people with disability perspective as well, that we make sure that there are not wide disparities in terms of pay within a horizontal or an occupational level perspective. I think thirdly, under this matter, Chair, so we have seen the proposal that remuneration be disclosed in terms of actual remuneration. Now, the dilemma that you sit with in terms of recommending actual remuneration is that for your executive levels, 60, 70%, and very often even greater percentages of total remuneration is made up of variable pay. And Chair, that variable pay is driven primarily by the performance of the organization and by the performance of the individual. Now, what you then end up with, if you have a look at just the top 20 JSE listed organizations over the last couple of years, and you track the pay of your prescribed officers and your executive directors, and you put it on a graph, you'll see a graph that sort of goes like this. And COVID times have went down, and then it went up, and so on and so on. So when you then bring in those actual data points into payback disclosure, the 1 year you're going to have a 1 to 40 pay gap, and the next year 1 to 200, and then 1 to 50, and so it's going to go on. And for people who want to track pay gaps by including the actual tracking of the pay of the actual tracking on actual remuneration will not be meaningful in our humble perspective from that point of view. So what we would like the committee to consider is to include pay gap disclosure on policy or target remuneration. In other words, if everything goes well in a 100% year, then what you should be seeing is year on year on year is that your pay gap stays the same. So you still will have in any event, like the colleagues from BASA has also explained earlier on, you will in any event still have your actual disclosure on what has been paid through your implementation report. So that information is available. But from a pay gap perspective, we believe that perhaps it's less meaningful for tracking pay gap over a period of time, particularly when you want to start doing a longitudinal study. So that is then with regard to section 30A3F. Chair, I'm going to then move on to the last matter, which probably is, I think, of most concern, not just to us, but also to colleagues in the industry. And that is with regard to the consequences from the proposed section 30A9 with regard to the stepping down of the Remuneration Committee members in the event that the proposed ordinary resolution is not passed in the 50% threshold. Now, I'm not going to bore the committee by repeating the comments which had been made by BASA. We completely concur with those comments. But I think from a practical perspective, what we just also would like to add is that in terms of our experience, it is very, very difficult for the Remuneration Committee to have an upfront knowledge necessarily of what the outcome is going to be of a particular vote. So at the moment, under the non-binding resolution on the implementation report, which is a retrospective resolution. So it's a resolution on past practices, past decisions. So the money has already flown through the bank, it's already been paid, so nothing can be done around that. There's a 75% threshold below which there has to be compulsory engagement for listed organization with their investors. And two things are very clear. From having now implemented this particular requirement under King 4 and under the listings requirements since 2016. The first thing is that there is no compulsory requirement for investors to inform organizations of their voting proxies. So very often what you find is that in the week, which is the lead up to the AGM, or in fact on the day of the AGM, there's a bit of a surprise for organizations, because that's the first time when they recognize and when they actually know what the outcome is of the voting against those resolutions. So without having a requirement that forces investors to make public their intended proxies with regard to those resolutions, it could well be that these Remuneration Committee members who are now required to step off the REMCOM if they don't meet the 50%, so not 75. So in fact, we're actually lowering the bar from 75 to 50. But if they then have to step down, it could well be completely a surprise to them, because they would not have known that beforehand, and particularly if they don't necessarily have a regular engagement with their investors. So that brings me to the second point around this matter, and that is we also believe, like BASA does, that the current requirement for compulsory engagement with investors, in fact, have been, from our perspective, very meaningful and has led to a lot of insight and changes to our remuneration policy through such compulsory engagement. What we have found in the year when we did not pass the 75% threshold, and there is a consequence where you have to invite investors to engage with you, that not one investor, in fact, had responded to that particular SENS announcement. And I'll see that now quite recently as well is one of the banks that put out a SENS to say, you know, we have made available the invitation for investors to approach us, those that particularly have dissenting votes to approach us, and nobody has in fact come forward. So it makes it very, very difficult for remuneration committees in the lead up to the AGM to even know where investors are, if there's no compulsory engagement, if there's no compulsory disclosure of such votes. The last point that I just want to make around this, Chairman, is talks to the succession, and I think our colleagues at BASA have also said had made similar comments, and that is in terms of the fact that you in terms of the skills matrix on a board, Chair, you would have your best remuneration skills on your remuneration committee. So you have a matrix. There's a whole lot of different skills that come on boards to make sure that there's good governance and that there's proper strategic leadership displayed. That when you then lose your 8 teams, so to speak, in terms of them stepping down when they don't make the 50% threshold, you're probably going to get your B team. And we wonder whether that in fact will suffice in terms of really addressing the objective of what we're trying to achieve with this particular bill, is having now, with all due respect to board members, directors on the Remuneration Committee who has no history, and they have to take over from their predecessors, and they don't necessarily even have remuneration skills, because that is a combination of people, remuneration governance, as well as financial skills that you bring to the party. So what we have said here on this particular recommendation is that perhaps that the sanction of 3 years perhaps be reduced then to 2 years of 1 year if the Honourable Portfolio Committee is adamant that there should be a sanction. Obviously, in the first instance, our preference would be no sanction, but they be then shorten that period, and that we in fact only implement that once 2 consecutive years of not passing the resolution have then passed. So this gives the Remuneration Committee the ability to at least address the issues which have been raised by shareholders through their vote. So from a practical perspective, your investors vote. They come to the AGM, you don't pass a threshold, and through compulsory engagement, the committee then reaches out to these investors. They have to then make known their reasons, because that's the other problem, is we very often don't get the reasons. And then there is an opportunity for that same committee in the second year to then change the policy, which then leads into the implementation report, because remember, the implementation report is just the outcome of a particular policy which has been approved on a previous occasion. So those are our 2 recommendations: is a shorter sanction period only after the second year, which very much aligns with the Australian practice. Not that we think it's necessarily relevant, because our social environment is very different from what we have in Australia, but at least it provides the Remuneration Committee with that opportunity to then address some of those concerns. The last thing that I just wanted to bring to the committee's attention is that in the last 10 years or so, Sasol has every year addressed investors who hold about approximately 50% of our shares, and sometimes even more. To cover 50% of issued shares, we have to engage, it differs, but typically around 20 different investing companies, and those are typically institutional investors. And to reach agreement with 20 different institutional investors are practically impossible. We have had situations where, and we give those reports to our boards every year, so the RemCom is extremely diligent in their engagement with those investors. But once you get to the end of your 20th engagement, you then try and figure out a way going forward where you say, you know, to meet this one's requirement and this one's requirement and this one's requirement is almost impossible. And what do we ultimately have to do in the best interest of the organization and the long-term future for sustainable performance? So and I think that is my point around the issue with a binding vote, is that you cannot change the past practice. It is very difficult to get agreement with investors in the first instance, and yet there's extreme consequence for those directors. Chair, I will then leave it here and then hand it back to Helene. Thank you very much.
Thank you. Do you want to add anything, Ms. Joubert? Otherwise, we'll go to the PC members.
Thank you, Madam Chair. No, I just want to highlight a few additional sections, not specifically in relation to Section 30, if that is okay with Madam Chair and the committee members. In relation to Section 45, we welcome the change. However, in the recent Steinhoff judgment in the Cape High Court, the question was asked which companies fall under Section 45. And we attempt to address the finding there to include foreign subsidiaries into this definition in order to ensure that there is no interpretation issues when it comes to alleviating the pressure within a group in relation to financial assistance. That is in relation to the proposal in Section 45(2)(a). We also further recommend that the definition of distribution is looked at consecutively with this proposed amendment. Currently, a number of legal firms are interpreting the issue of guarantee to also require solvency and liquidity test with regards to, as I mentioned, specifically guarantees, because of the definition requiring not only a debt or an obligation by a company for the benefit of one or more holders of any of the shares of that company, but also expands it to indicate or for another company within the same group of companies. Therefore, a number of legal firms are applying it in the same manner as Section 45 currently stands, which also places an additional burden within a large group of companies such as Sasol. The rationale for this proposal, the definition of distribution read with Section 46 provides for a duplication with Section 45 and an additional unnecessary compliance burden within a group of companies. A distribution is the transfer of money or property for the benefit of its shareholders, and we've always seen the aim of Section 46 as being that. By the additional wording, as I mentioned, to expand it to within the same group of companies. The pure intention of this distribution is expanded unnecessarily, and if this section is interpreted in this manner, the burden which the amendment in Section 45 aims to achieve will not be alleviated in the manner as we think was seen. I'll move on, Madam Chair and committee members, if I may, to Section 61(8)(c) and Section 72(9)(a). Although not a huge concern, this is more for clarity purposes. Currently, the election of an audit committee is as it's being stated in the Companies Act. This is being expanded to the election of a social and ethics committee. We are proposing that we manage it in the same way, and as organizations have been doing it, the interpretation is that it's not the election of a committee as a whole, but the appointment or election of members of these committees on individual basis. They are being proposed for election at the AGMs. And for clarity purposes, we are just recommending that perhaps the words members of an audit committee or members of the social and ethics committee be specifically mentioned in the recommended amendment. Section 72(7). The purpose of our proposal here is to ensure alignment with the purpose of the sections being proposed. And this is to enhance the independence of the committee. I think it was maybe an oversight. If one reads the section, it currently says it must consist of a director who is involved in the day-to-day management of the business of the company and must not have been so involved within the previous 3 financial years. We're just pointing out that this section should probably read who is not involved in the day-to-day management of the business. Chair, if I may move on. There's one last additional amendment that we are requesting the committee to look at. Currently, Section 610 provides that if in terms of this Act, a notice is required to permit it to be given or published to any person, it is sufficient if the notice is transmitted electronically directly to that person in a manner and form such that the notice can conveniently be printed by the recipient within a reasonable time and at a reasonable cost. We are recommending that the following wording be added to enable other forms of electronic communication. Currently, the section is being interpreted that the direct delivery of, for instance, a notice of AGM means that the actual notice needs to be attached to the method of electronic delivery. So we are requesting that this be expanded to say, or a notice of the availability of the notice is transmitted electronically to that person, together with the instructions for receiving the complete notice, which will enable the person to conveniently print the notice within a reasonable time and at a reasonable cost. Our rationale for this proposal is that a number of platforms and other forms of communication are available which provide links or access to documents. As this section currently reads, the full text of sometimes voluminous circulars, notices of shareholders' meetings, and the like must be sent by email or post. This is not realistic or practical in a country where internet access is limited, data costs are high, and the mailing system is unreliable. Chair, I will pause there and stop sharing my screen. Thank you very much.
Thank you very much for your presentation. I will now give an opportunity to committee members to interact with your presentation. PC members. Honourable Macpherson.
Thank you very much. I just have a quick question. So you've obviously clearly articulated that there is no change in the pay gap in other countries where it's been published, and I'm unsure whether it has been done to the extent that is envisaged within the bill. And if it does, what has been found in terms of the ability to attract talent to listed companies or companies that are required to publish information like that, and your thoughts or comments around the ability to attract and retain talent, specifically regarding the pay cap or pay publishing perspective. Thanks so much.
Chair, would you mind me to responding?
Yes, I don't see any other hands from committee members, so that's the only question. You may proceed with the response.
Thank you very much, Madam Chair. Honourable Member Macpherson, I'm just going to give you two examples of what we very often look at. The one is in the UK, and then there's also in the US. So the methodologies for pay gap disclosure is very different in those jurisdictions. In the US, there is the CEO versus the average of all other employees as a pay gap measure for listed organizations, primary listed organizations, which have to be disclosed. We also have in the UK a requirement where there is the median performance. So it's the median remuneration, which is then disclosed there versus the CEO. So has it had an effect on the ability to attract talent? I don't believe so, for two reasons. The one is that executive disclosure, so pay disclosure, has been in the market for many years. So longer than 10 years, executive pay has to be disclosed. And when individuals make themselves available for particular positions, that just comes with the territory, is the fact that your pay is going to be placed on the notice board. So I do not believe that it has a negative impact on the ability to attract talent. What we have seen now of late with the EU directive on pay gap disclosure is that they have completely in the European Union moved away from pay gap disclosure on a vertical level, but have focus, which we believe is where the focus should be, on horizontal pay gaps. In other words, where employees are on a particular occupational level, that in terms of the EU directive, and there's 3 years for organizations to comply with that particular requirement, is that there should not be a disclosure, my apologies, there should not be a gap between women in particular, so there's a gender focus there, of more than 5% between women and men in an occupational level. So there is obviously where the focus should be, is horizontal pay gap, but in both UK and US jurisdictions, in fact, the pay gap has just become wider and wider. Now, the reason for that as well is if you just if you just do the basic math. So if somebody at the bottom of the organization earn 100,000 Rand, and somebody at the top of the organizations earns R1 million, but they both get a 10% increase, then your so you now have a 10 times gap. So then at the bottom of the organization, the person gets 110,000, so it goes from 100 to 110, but at the top it goes from 1 million to 1.1 million. So immediately your gap, is 90,000 rand more. Now we have seen over the last couple of years in South Africa in particular, but also in the rest of the world, that there has been very meaningful differences in terms of annual increases, where employees at the lower level of the organizations, and particularly those at the living wage level or the minimum wage level, get higher percentage increases. But the difference, if you give a 6% increase at the lowest level of the organization versus a 3% at the top of the organization, does not do anything to meaningfully address the vertical pay gap. So it is an absolute red herring that your vertical pay gap will reduce just simply by putting that information out in the marketplace.
Okay, thank you so much. I see the end of Honorable Thring. We have 5 minutes left.
Thank you, Chair. Chair, yeah, just two comments from my side. One would be it's a very interesting take on the horizontal versus the vertical pay gap and focus. And I think very clearly our focus has been more on the vertical pay gap and the disparities between your top executives and your lower paid workers, and whether that particular gap is going to be reduced or not, I think is obviously up for discussion. Although there are many who would obviously want to see that reduced. I think we all want to see workers getting a more of a living wage because of the rate of inflation. So I think my question would be, what are your recommendations in terms of those huge disparities? How are we able to, in terms of the vertical wage gap, what recommendations, if any, do you have to address that? And if you feel that it's the recommendations within the bill are going to be actually meaningless, but what recommendations, if any, do you have to address that? And then secondly, Chair, was just a comment, and I think I missed it, was with regards to Steinhoff, and perhaps the bill has missed what needs to be done in terms of the Steinhoff case, and I kind of missed what they were actually saying, and if they could just repeat that. Thank you, Chair.
Honorable Monakedi.
Thank you very much, Chair. I just want to check, in terms of their presentation, they are indicating there that their first option, as far as the stepping down or not of members of REMCO in a case of non-approval of the remuneration report, is that they should actually not step down. And of course, they've got the other alternative or other options of reducing the period. But in a case where they don't have to step down as they are proposing, what sanction are they envisaging? Because obviously the reason why there has to be the stepping down is a way of ensuring that there is accountability. So how do they then ensure that there is accountability if they are proposing as the first option that they don't need to step down? Thank you.
Thank you very much. Ms. Nienaber.
Chair, thank you very much. So let me start by addressing Honourable Thring's comments with regard to the pay gap. So by putting pay out in the marketplace, pay information and pay gap in particular is not going to do anything, in my very humble perspective, around closing that gap. What we have to do is we have to ensure that we create opportunities for employees at the lower levels of the organizations to grow. They have to build their skills, they have to move up in the career paths, they have to have the ability to grow their own income through moving up into organizations. Now, in order to do that, we must know that organizations are economically viable. And that is why we also are so concerned that, I'm sure the JSE has mentioned to you the number of organizations that have delisted over the last number of years. So we discourage foreign investment into the country with very, very onerous requirements, particularly the one that that relates to REMCO members stepping down. So my view is that we need to do far more in organizations to create jobs, to create access to the economy, to create skill building, to create the ability to move up in organizations. That is where we need to make the difference, because South Africa doesn't necessarily have a pay problem. We have an income inequality and a wealth inequality problem. And by putting the few employers who are trying to really make a difference and trying to create employment under the whip is not necessarily going to make a meaningful difference in my perspective. So it is around really making sure that we create opportunities for the most vulnerable members of our society to grow and to earn more, to improve their standard of living, to be able to send their children to school and to universities and participate meaningfully in the economy. I'm going to just ask my colleague Helene to address the matter of sign-off, and then I will revert then to Honourable Motolani's question.
Thank you, Ronel. Thank you, Madam Chair and committee members. In relation to the sign-off matter, so currently how Section 45 reads, it's been interpreted in that judgment that foreign subsidiaries currently also falls within that section, and therefore, if you apply your approval and solvency and liquidity test required in terms of Section 45, you also have to do it if there's a foreign entity within your group of companies. Therefore, currently as the proposed amendment reads, it says that it does not apply to the giving by a company of financial assistance for the benefit of its subsidiaries within the same group of companies. But if you look to the Companies Act in terms of the definition of a company and the subsidiaries, a foreign entity is still excluded, which then implies or can lead to an interpretation difficulty of whether foreign subsidiaries will also be exempted even if they are part of a group of companies. And therefore, we are proposing that the section be amended to specifically state that it does not apply to the giving by a company or another company within the same group of companies of financial assistance to or for the benefit of its subsidiaries as defined in Section 1 of the Act, or a person that would have been a subsidiary as defined in Section 1 of the Act, but for the fact that it is incorporated outside of the Republic of South Africa. So therefore, we just want to ensure that there are no interpretation issues going forward, that in fact a whole group of companies being South African registered or foreign subsidiaries are exempted from this onerous obligation in Section 45. Thank you, Madam Chair.
Thank you.
Madam Chair, then through you, just in terms of Honourable Motolani's question, in terms of the sanction. So from a process perspective, there's a policy document that sets out how executives should be paid. So you have directors and executive and prescribed officers. And as it stands at the moment, our reading of the proposed amendments is that the policy should be only focusing on that group of people. Now, when you look at remuneration policies at the moment in South Africa, then in terms of King 4, it is very clearly stated that such policy document should address executive remuneration in the context of all employees. So it should be fair and responsible and transparent in the context of all employees. So what we're now going to do through this particular amendment is we are going to have a policy document that's going to have 2 or 3 pages that only addresses executive pay, because you do not want to give shareholders the opportunity to vote on a policy document that covers the entire organization. So that's the starting point. So now you have a policy document, and the policy document then states that this is how you pay people, this is how you determine salaries, this is how you determine short-term incentive, this is how you determine long-term incentive. The outcome of implementing such policy is then disclosed in the implementation report. So Simon has a salary of so much, this is how we calculate his bonus, this is how we calculate his long-term incentive. The outcome of that policy document is then set out in the implementation report. So this is how we have now given him money in the last year. So that's water under the bridge. The money has been paid, it's been calculated. So by now putting down a vote by shareholders to say, but we don't like how you've now paid Simon, doesn't point to how we've calculated the pay. It actually points to the fact that there's 1 or 2 things wrong. Either the policy document isn't right, so you disagree with the way in which the policy had been written, or the remuneration committee or the board has now applied discretion and have deviated from such policy document. So the question in the first instance, honourable member, is why is there a sanction if in the first instance the remuneration committee doesn't even know why there are dissenting votes? So they don't know, because there's nothing that compels investors to inform organizations before the AGM of their intention to vote down on a particular resolution. So in the first instance, we don't know what the reason therefore is. In the second instance, there's very often reasons where people just say, you know what, I know this is your policy, but I don't like the outcome, because people object against an absolute number. So it's not the policy, it's not the implementation, it's just the fact that people just feel that it's completely horrific that people earn 100 million rand a year. It's just, for them untenable, and they vote against an absolute number. So I'm not 100% sure why there is a need for sanction unless we understand the reason for such outcome of policies. And I think it's already tough as it is, to serve on a remuneration committee, because it is not an absolute science. It's very much an area where you have to apply significant discretion, significant judgment. Very often, those REMCO members have to face executives and say, I know this was the outcome of the formula, but you know what? We disagree with it, and we are actually giving you less money. So as it is, it's really a hard role for them to play. So Honourable Motolani, with regard to your question, what is the sanction? I do not believe that there should be a sanction until such time that one actually completely understands the reason why a particular report is voted on.
Thank you very much. Your explanations and your motivations have been quite helpful to the committee. Thank you to Team Sasol, and we'll move on to our next presentation, which is from the National Clothing Retail Federation of South Africa, led by Mr. Lawrence. Thank you. You may share your presentation. Thank you very much. Goodbye.
Thank you, Chair. Thank you, committee members.
Good morning, Chair, and good morning, committee members. I'm just trying to work out, do I have sharing rights? And yes, I can.
Yes, you can. Yes.
Thank you,
Thank you. Good morning.
Morning. Chair, let me just make sure I've got the right presentation up.
Yeah, and may I apologize that we are running a bit late. Please accept our apologies.
No, Chair, no problem at all. In fact, my intent is to get you back on track time-wise.
Good.
Chair, again, thank you to the committee for allowing us in the first instance to have made a written submission. I'm going to just cover a few areas of emphasis in respect of our written submission. A number of we have as individual members of the federation and in terms of our role, of different roles at NEDLAC and the like, made a whole number of inputs into this very complex conversation. And as I said, we would like just to share a few thoughts, having already heard a number of well articulated arguments on some of the concerns. Chair, I've taken the liberty of just indicating the inclusion of some of our membership quite deliberately, and our employment. Our concern here, Chair, is the retailers, the clothing retailers that typically look for opportunities to get listed have statistically shown that they are very attractive opportunities for foreign investment in respect of a number of the listed companies whose names are on the screen at the moment. We're very proud of the fact that the strong commercial elements of and the strong way in which we are regarded commercially across the world as clothing retailers has made us a very attractive destination for foreign investment. That's important. We don't want to confuse our investor community. We'd like to give them a sense of confidence, a continued sense of confidence in how we function, what we do. We also are very mindful of the fact that we have a very strong role as a value chain as a key part of the value chain to play in the development of jobs, not just in South Africa in the industrial sector, but also in industry and services, even across the continent. So Chair, we think it's absolutely critical that what we don't end up doing by virtue of a number of elements of the Companies Amendment Bill as currently being considered by Parliament, by this committee and by Parliament, is that we don't end up with a consequence that creates uncertainty, investor uncertainty, institutional fund uncertainty, and undermines the job creation and commercial development that is possible, we believe, especially in the value chain we serve. Chair, I'm going to make reference, with respect of, I'm going to suggest that the members use the written submission. So our concerns in the first instance around sections 26, 1 and 2, and Chair, we have concerns here that there is a risk here for price-sensitive information where there are wholly owned subsidiaries as part of these listed companies. We're very worried, Chair, about the fact that we could end up here finding that there is access to annual financial statements virtually on a willy-nilly basis. And sometimes we suspect that an unintended consequence could in fact be that a private company and the privacy of a private company could be substantively impacted. We are just worried about the way in which remuneration will need to be concerned, and I will come to section 30 shortly. But Chair, it does appear to us that while we have currently a regime where there is areas of confidentiality in financial information, which is important from a competitiveness point of view, product competitiveness. We are very concerned about the importance of competition and healthy competitiveness that we could have a situation where we actually undermine even competitiveness within listed companies, and even in particular with private companies. We are of a view, Chair, that the Promotion of Access to Information Act for critical information does make provision anyway, and we really don't believe that the kind of information access that is suggested here is appropriate or necessary. Chair, the issue of remuneration, a number of parties have already spoken to the named directors' disclosure of remuneration. We are of the view, Chair, that every director is fundamentally a data subject in their own right. But Chair, it goes even a bit beyond the protection of personal information. It has been made very clear to us that there is a risk of criminality when individuals' personal wealth and personal income is disclosed. We are running a risk at the moment of using the wrong tools, as has been indicated by a few parties already. Problems are identified and articulated within the intents of what is to be addressed in the amendment bill, but we have completely inappropriate tools. And Chair, while to some degree there is already disclosure of remuneration of directors, what we're seeing increasingly is going to be a grand mass disclosure of personal income that has huge implications in terms of the personal protection of information for individuals. It has huge criminality implications. It has huge problems in respect of measuring parties who believe they may be in creating all kinds of tensions with parties who believe they should be differently remunerated, but there may be substantive commercial reasons for not doing so. Chair, the issues around, I said around Section 30A have been, even in this morning's presentations prior to mine, have been substantively, I believe, addressed already, and in particular by the parties who have just gone before us, both BASA and SASOL. The challenge of trying to understand here the implications of how the Remuneration Committee is supposed to become a mind-reading exercise with all the information available at their disposal. They become extremely vulnerable. They run the risk of receiving a consequence that is in no way appropriate to even to an error which is well-meaning. There would be substantive problems. We really don't think that it is appropriate that this degree of pressure is placed. It's important that what we do have instead is a robust shareholders engagements, but unfortunately the very nature of complex shareholder communities we think creates complexities here that results in consequences to a set of experts that is completely misaligned and is completely inappropriate for the kind of problem that has been identified. Chair, then the pay gap, again, the reason I didn't want to but to keep the committee's time for longer than necessary. Again, the pay gap disclosure and the mandatory requirement, there too, we see no evidence anywhere where pay gap disclosure has necessarily resulted in it being made any smaller. What we believe should be a critical part of consideration by the regulatory and legislative architecture is, as has been articulated by other speakers and is shared by us as well. We regard not just our value chain, but our retail segment in particular as having huge opportunities, providing huge opportunities for start out for young people, especially disadvantaged, marginalized, to start professional journeys. I'm fairly sure that if I walked into a room of 100 people, 80 of them would say that at some stage they had worked in a shop, and probably half of that 80 would say that it had been a clothing store, because that's a very attractive place to start work. It's a great place for skills to be developed. So skills development and the opportunity for growing individuals and growing their entrepreneurial skills, the ability to drive commercial value, the ability to themselves climb the ladder and in fact close the wage gap in and of themselves should attract a lot more attention than simply trying to put out numbers there, which we believe fundamentally simply just create enormous amounts of tension, which are inappropriate to the circumstance they're trying to resolve. It's also very difficult when you have, as I indicated in my opening remarks, Chair, when you have businesses such as ours, which can run in many countries, which both source from many countries, and are supporters of value chains even outside of South Africa, and then themselves are positioned in order to provide services and add value. A lot of retailers are busy expanding, as I'm sure the committee members are aware, not just through Africa, but are seeking to expand across many continents, in fact. And we find it's not, you're not measuring apples with apples if all you're just doing is measuring numbers. So we do have a substantive concern about that. Chair, there are some concerns around the way in which the Social and Ethics Committee will need to be constructed, and again that's been indicated again by a number of parties before myself. We have support for the function of the Social and Ethics Committee. It's always the case that companies are trying to give as much information as possible to their respective shareholder communities, and the social and ethics reports we believe are important. But the issue of having all kind of prescripts around the Social and Ethics Committee, we believe is something that should be left to the architecture of the business itself rather than to the legal and regulatory architecture. Chair, just some general comments. We're busy apportioning, we believe, an environment, we're proportioning support to an environment where shareholders can be quite destructive in respect of what they understand their own interests to be, where the intent of a company and the purpose of a company was to develop both a community and a juristic persona that would substantively look after its interests, grow its interests, and as a consequence would add benefit to a number of stakeholders, including the shareholders. We just worry that what we may end up here is providing shareholders with a whip that provides them with an opportunity to look after their own interests, even to the harm of other stakeholders. Shareholders can exercise authority and create consequences, which if it had been similarly exercised by directors, would result in consequences in respect of their statutory or fiduciary duties. But shareholders are being given an opportunity to incur negative consequences without having to take responsibility for them. And so we can't again see any jurisdiction where there is a binding vote on the REMCO implementation report. We're very worried about the fact South Africa runs the risk of being an unattractive, risk-laden country to invest and do business in. And we're very worried as mostly public companies, but as companies, as a collective community that has opportunity for that should be providing opportunities for more and more public companies. We're very worried that there will be high liquidity and a very fluid shareholder base. Chair, I'm going to stop there and simply re-emphasize that we think our concern is that we really have tried to identify problems which need to be addressed in other areas of government and governance and other areas of statute and regulation, and have been instead introduced with major complexity. And once the regulatory framework gets opportunity to play out in the context of the framework that the bill now has, we could have serious prejudice to the way in which business can grow and attract growth and create jobs in this country. Thank you, Chair.
Sorry, my apologies for the frog in my throat. Thank you very much. Committee members, can I have an indication of discussion? Honourable Thring.
Thank you, Chair. Chair, I think Mr. Lawrence obviously raises concerns raised by the different entities, sectors that presented in terms of the fact that disclosures may undermine competitiveness. I think what nobody else seemed to have raised was the criminality aspect of the disclosure of remuneration. And I don't know whether certainly some thought needs to go into that. With the kidnapping and so on increasing in South Africa, and one just needs to look at the police stats, and you will see that is an area where that is on the increase, and I don't think that attention was actually given to that. So I do think that closer attention needs to be paid to the criminality aspect with regards to the disclosure of remuneration. I think that, like others also, they are also not supporting the requirement to approve remuneration of a policy by a binding vote. My question here, Chair, is if the bill goes through, to Mr. Lawrence, if the bill goes through in its current form, what, in your opinion, do you think this would have on the clothing retail sector? That's from your employees right up to the effect on the different value chains within the clothing sector. Thank you, Chair.
Thank you, Honourable Thring. Honourable McPherson.
Thank you, Chair. Good morning, Mr. Lawrence. Mr. Lawrence, you would know, I mean, you obviously represent clothing retailers, which are, by their nature, some very big companies, some companies that also have are multinational, so to speak, and that they have operations on other continents and other countries. You said that this may have consequences for businesses and doing business. Could you elaborate in the context of the organizations that you represent, how that would adversely affect them, and also some of which are also listed as well? Can you give some practical examples of how this bill would impact their ability to do business in South Africa and also possibly in other parts of the world? Thank you so much.
Thank you. Over to you, Mr. Lawrence, for responses.
Thank you, Chair, and thank you to the honourable members. They've asked very, very similar questions. I'm going to try and weave the answer to the two honourable members into the same response. Chair, if we look at the value chain, the clothing, textile, footwear, leather value chain, it is identified across the world. We had an anomaly in South Africa before 1990 that our value chain was in fact dominated by the manufacturing sector, and for example in automobiles, manufacturing calls the shots by and large in terms of the driving the way in which the sector has to function and what the sector produces. In CTFL, it is across the world. It is typically retail, and post 1990, both with the globalization and with the opening up of our economy, that became very true and very real. And our clothing retailers have proudly made a mark, not just in this country, but again, as I said earlier, across the continent, across the world. There are many instances, Chair, of many of the NCR, not just the NCRF community, but a number of other retailers as well, clothing retailers, having positioned themselves very well. Primarily, if I were to go off the continent, in Europe. In Australia, yes, there've been. Everyone can talk about where things have not worked, but if you look at the profile, the kind of multinational profile, as Honourable Macpherson called it, of a number of these retailers, and the opportunities for multinationalism and being able to position multinationally and being able to be, as I indicated earlier, a support to both an industrial competence and capacity, as well as to a number of services, logistics, IT, and financial. I can go on and on and on. We have positioned the sector with pride internationally, and that's why we attract a lot of investment, but we attract very, very, very good skill, very good competence. In our executive communities, in the C-suites and the exec community just below the C-suites. And we also get very strong competence in a number of those service sectors. We're one of the fastest developing IT sectors in support of our processes. We have some of the best distribution services across the world, again. Challenged, of course, by the likes of our own logistics infrastructure here, challenged, of course, in South Africa by the unavailability of power often, and we've spent a lot of money as retail on supporting power. We're a player. We're a substantive player. We're proud to be a player. We're proud to be an enormous part of economic growth. We're proud of the fact that we can, as a retail, that when we made a call 4 years ago to substantively work with the entire value chain and a number of government departments and agencies on what is commonly known as our master plan now. What we have done is substantively move the needle already in a few years in respect of local content sourcing, of local manufacturing, so there are things, honourable members, where we recognise we have an ability and we can change. We recognise, honourable members, that part of why we change is because we are global players, because we are players that get taken seriously, because we attract the right kind of talent, because our investment architecture and our skills development architecture and our processes are world-class, world standard, and we think that in a number of elements that are now being introduced via this bill, that we will run the risk of not being so attractive. We will run the risk of not attracting the best of talent, of the best of skill sets across the world. We will run the risk of having difficulty, again, when I said, if I have to compare someone whose salary is has to be compared with an individual that only works in one country, but I have a top executive that has to compete because of the complexity of their task with talent from across the world, and has to compete in an international environment, very especially as we're getting more and more interested in a continental environment. Well, I'm not going to get the best of the best. I'm not going to get the best of investor money. I'm not going to get the best of personal and individual talent. I'm exposing, we're creating cracks in exposure, and we live in an era where information like that gets passed on very quickly, and claiming back your losses is increasingly difficult. So while we believe that while we are doing as well as we are doing, we'd like to do better. If we put ourselves in a situation where we're vulnerable, and because of legal and regulatory architecture of where our head offices are situated, being in South Africa, and we're proudly South African, many of the members, there are non-South African members in the Federation certainly, but we're proudly South African by and large. It creates an enormous problem of consequence to our economy that we believe is not appropriate for the way in which the legislation and the statutory environment should be paying attention.
Thank you very much, Mr. Lawrence, for your presentation. You have been heard. We will now move on to our next presentation, which is from Baker and McKenzie, and it's Ms. Sheer Fisher, who's going to manage the presentation for us. And also apologies for the now 10-minute late start to your presentation. Thank you very much.
Morning, Chair. No problem on the lateness. I'm not sure if we'll be able to make up some time, but let's get started. Thank you all for the opportunity to present our submission on the Companies Act Amendment Bill to the committee. By way of introduction, I'm Kaylee Sheer Fisher, a Senior Associate in the Corporate M&A team at Baker McKenzie, South Africa. Baker McKenzie South Africa is a South African law firm and part of the global law firm Baker McKenzie. We opened the office in South Africa 11 years ago and are very much an active part of the South African. Can you just take your presentation into slide mode, please? Sorry to interrupt. Sure, sorry, no problem, Chair. Jordan, are you able to...
Sorry, Chair, are you able to see my screen?
You're unable to? I think just proceed, Ms. Sheer Fisher.
Oh, sorry, it seems that we're having some technical difficulties. Okay, there we go. Is that better?
Yes, thank you so much. Proceed.
Great. So essentially what I was trying to set the scene as to why, we have some comments on the amendment bill. We corporate law and M&A attorneys, and we deal with our client queries on the Companies Act on a daily basis, and we are required to comply with, uphold, and implement the provisions of the Companies Act on a practical level in real-life transactions. We also deal with numerous clients who are looking to invest in South Africa and have specific questions in respect of the Companies Act and the regulations that govern our landscape. In our view, the Companies Act needs to be a piece of legislation which balances public interest and policy with the ability of companies to structure and implement transactions in South Africa easily and with certainty. South Africa is currently rated around number 84 by the World Bank on ease of doing business, below numerous other African jurisdictions. This ranking suggests that it is imperative for us to look to lighten the load for entities wishing to do business in South Africa rather than making it more burdensome. It is this balancing act of public policy versus ensuring a piece of legislation that can be implemented and adhered to with certainty and ease that needs to be kept in mind when considering the proposed amendments to the Act. As a start, we would like to commend the Portfolio Committee for what we believe to be some positive amendments to the Act, many of which will enhance certainty and ease of doing business in South Africa. For example, the proposed amendments to Section 40 Sub 5, Section 45, and Section 48 are welcomed and much needed. However, we do believe that some of the proposed amendments require certain clarifications, and in respect of others, we believe there may be unintended negative consequences should the amendments be enacted. I will now deal with each of our specific comments on the proposed amendments, some of which are more technical in nature. Our first comment is on the proposed amendment to the definition of securities. The current definition references shares and debentures and any other instrument, and the proposed amendment seeks to remove this reference to any other instrument. We believe this would result in the definition being extremely restrictive in nature and failing to capture hybrid instruments and other instruments that would fall between a share and a debenture. Our concern is that this restrictive definition could lead to a manipulation of the Act, with arguments being made that certain provisions of the Act which reference securities will no longer apply to certain types of instruments that should in fact be governed by the Act. It is our proposal, therefore, that this definition be extended to include not only shares and debentures, but any other instrument which would give the holder thereof voting rights or entitle them to receive an economic benefit. We believe that this proposed definition would narrow the application of the current definition in the Act, but still be broad enough to capture those instruments which should be governed by the Act. This will also ensure alignment in respect of the definition of securities across various other pieces of legislation, such as the Financial Markets Act, as well as the JSE and CTSE listing requirements. Our next comment is on Section 25 and the proposed amendment here. This is a more practical submission. Currently, the Companies Act requires companies to file a notice setting out the location where certain company records need to be kept, and the amendments now require the CIPC to publish this notice as prescribed. However, the proposed amendments fail to sufficiently deal with what the CIPC is actually required to do in this regard. We would suggest that the company's regulations be amended simultaneously or immediately following these amendments to ensure certainty is provided here as to where this notice will be published and the detail that will be contained in this notice. We believe that publishing a guidance note in this regard will not suffice and that the detail should be included in the regulations. Our next submission is in respect of the amendments to Section 26 of the Act in relation to access to company records. A number of amendments have been proposed to this section. However, the one specific amendment that we'd like to focus on is that which allows people who do not hold a beneficial interest in a company from requesting copies of certain records upon the payment of a fee. These documents will include a copy of the company's securities register. And in terms of the most recent amendments to the Act recently introduced by the General Laws Amendment Act on Anti-Money Laundering and Combating Terrorism Financing, a non-affected company is now required to include in its securities register details of its beneficial owners and beneficial interest holders if applicable, and affected companies must prepare a separate beneficial interest register, which is required to be submitted to the CIPC. The information that will be included in these registers will include identity numbers and passport numbers of persons, if available, their email addresses, as well as their direct or indirect percentage shareholding in the company. In our view, permitting a person who has no beneficial interest in a company from obtaining such information will infringe upon such person's right to privacy and should not be permitted. In addition, the rationale for the inclusion of such information in the securities register, as well as the requirement to file this register with CIPC, is to provide government authorities with access to up-to-date information concerning the ownership of companies for purposes of anti-money laundering and prevention of terrorist financing. This information should therefore only be shared with the relevant regulatory bodies who require this for this purpose. Allowing this information to be accessible to the public seems to us to be a fundamental policy change. For example, in terms of RICA, if a person wants access to their own information, they are required to submit a PIA request. If this amendment is enacted, it will give the public access to personal information that would otherwise not be accessible under any piece of legislation. In addition, we believe that many foreign investors will be wary of investing in South Africa, knowing that their information can be accessed by the general public on submission of a request to the CIPC and payment of a fee. We believe that companies should be permitted to redact the beneficial interest and beneficial owner information when responding to requests in terms of Section 26(2). In addition, we believe that even parties who hold an interest in the company and are requesting such information should be only provided with this information on good cause shown. For example, if they need to show who other shareholders are in the company to comply with their own anti-money laundering policies. Our next comments are on the amendments to Section 30. Currently, companies are required to include in their annual financial statements the remuneration of directors, both executive and non-executive, as well as persons who are considered prescribed officers. The proposed amendments now require that the name of the prescribed officer also be included in the financials. When we're looking at the definition of prescribed officer in the Act and the application thereof to individuals, this is a fluid application, and depending on the specific duties and authorities given to persons, they may or may not at varying times fall within this definition. Therefore, it depends on when the analysis is conducted, and different people may be considered prescribed officers at different times. This amendment may very well result in senior management being named alongside their specific remuneration in the financials, where previously this was captured as an aggregate amount and often included in the total employee remuneration. Disclosing this information could result in sharing of salary information amongst employees, which companies often try and keep confidential. In addition, we fail to understand what additional policy objectives are trying to be achieved by specifically naming these individuals, and do not necessarily believe that this will assist in bridging the wage gap. We believe this amendment should not be enacted and that the section should remain unchanged. Our next comment is on the new Section 30A, and I think a number of other submissions have been made in respect of this, which we wholeheartedly agree with. Our comments here are twofold. One, from a practical perspective, we believe that the wording in Section 30A itself needs to be updated to provide clarity as to how shareholders are actually required to vote on these matters and the consequences if the requisite approval is not obtained. We find that some of the sections, for example, Section 30A and Section 30A sub 5 and Section 30A sub 6 are contradictory in nature, and it's unclear whether the voting in respect of the reports and the policies and the implementation report should be separate votes or whether they constitute one vote. It is also unclear to us that what would happen if the policy is not approved, in the fact that Section 30 sub A will only provide that the policy must be presented again at the next AGM. In the first instance, we believe that this uncertainty in the Act must be rectified. However, it is our strong recommendation that any vote of the shareholders in respect of these policies is treated as advisory in nature rather than binding on the company. As I previously mentioned, we agree with a number of other submissions on this point and believe that shareholders do not have expert knowledge or the requisite information to make decisions about a company's remuneration policy. And a binding shareholder vote will result in blurring the lines between ownership and management. The board needs to be able to retain its autonomy separate from shareholders to discharge its fiduciary duties, and part of this is determining an appropriate remuneration policy without external shareholder influence. While we acknowledge that this proposed new section of the Act brings the Companies Act in line with the principles enshrined in King 4, even King 4 prescribes that the presentation of the remuneration policy and report at the AGM be tabled as a non-binding advisory vote. Our final comments on the proposed amendments relate to Section 72 and the Social and Ethics Committee, and this again is more practical in nature. Currently, a company is permitted to apply to the Companies Tribunal for an exemption from the requirement to appoint a Social and Ethics Committee, and the amendments propose that prior to such submission, a company must now first publish its intention to apply for this exemption. From a practical perspective, again, the proposed amendments provide little clarity as to what this means. Amendments to the regulations will therefore also be required to provide certainty as to where the application must be published, the consequences if it is not published, and any applicable timing. In addition, it needs to be understood whether interested parties will be able to object to this application and whether the Companies Tribunal will take these objections into account when making its decision. Depending on the specifics of the above and the intention of the legislature in this regard, the committee should carefully weigh up the public interest this will serve versus the additional hurdle it will create to doing business in South Africa. Thank you, Chair. I'm happy to take any questions.
Thank you very much. Members, can I see hands for interaction with the presentation? Members, do I take it you have no questions? Honorable Thring?
Thank you, Chair. Chair, maybe just one question from my side. It was recommended that the bill needs to give clarity with regards to shares and debentures, and that it needs to go a little beyond shares and debentures. So what are some of the additions that you would like to see? Having, you've defined shares and debentures, but what are some of the other things that you feel have been excluded or is not properly captured within the bill that you would like to see besides shares and debentures? Thank you, Chair.
Thank you very much. It seems that's the only question, Ms. Fisher.
Sure. Thanks very much. And thanks for the question, Honourable Member. So from our perspective, rather than taking the approach of specifically listing certain other instruments that's been done in some of the other pieces of legislation, like in the Financial Markets Act, we were looking at a more holistic definition that would capture any type of instrument that gives the holder thereof voting rights or an economic interest in the company. Specifically referencing, for example, convertible notes or other types of hybrid equity instruments will potentially result in again being too restrictive. And we see in the market that people are coming up with different types of instruments, giving different rights to people, and these instruments should be governed by the Act. By having this restrictive definition, it may result in a situation where an instrument that, for example, should be subject to Section 44, financial assistance, or offers to the public will now no longer fall within those sections. So for us, rather than listing specifics, we were looking for a kind of definition that links an instrument to economic and voting rights, as we believe those are the types of instruments that should be governed by the Companies Act.
Thank you very much. And thank you for bringing us back on track in terms of time. Thank you very much for that presentation. The committee will now take a short break for 10 minutes and we'll reconvene. I think let's reconvene at 11:15. Thank you.
Are we muted?
Morning to everyone on the platform. I hope you've enjoyed your short break. We will now resume with a presentation from Just Share, and I think it's Ms. Ngogela. Oh, Mr. Ngogela.
Chair. Thank you very much. Chair, I hope I am audible.
You are very audible, yes.
Good morning, Chair and fellow committee members and everybody in the platform. And members of the public, if there are any listening. If I may share my screen.
You have co-hosting rights, yes. Here we go.
Thank you, Chair. We thank the committee for allowing us the opportunity to provide verbal submission on the company's amendment bill. I am Kwanele, and I work as a senior inequality analyst at Just Share. Our presentation, this is a quick outline of our presentation. Chair will introduce ourselves. We'll quickly touch on vertical wage gap disclosures and some of the work that we are doing related to wage gap disclosures in our advocacy. We'll also touch on the issue of inclusion of the lowest paid workers in the disclosures. We'll also argue for the inclusion of gender wage gaps to the Principal Act or to the current bill. I will also touch on the binding votes on exec remuneration. Chair, Just Share is a non-profit shareholder activism organization. We believe that the responsible investment is necessary to create a just, inclusive, and sustainable economy. We use engagement in the work that we are doing and advocacy and activism to drive urgent action to combat climate change and reduce inequality, which is more relevant for today's purpose and our submissions. Chair, our rationale is that, as we know, that South Africa is one of the most unequal countries in the world. And we understand from Stats SA that the labor market remains one of the key institutions through which exceptionally high levels of both vertical and horizontal inequality are transmitted. By vertical, as the committee would know, we refer to inequality or the pay gap between the highest earners, which will be executives, and those who are in the lower ranks of a company's workforce. On the other hand, horizontal income inequality can be racial inequality or gender wage gap across all occupational levels in a given company, of course. So, Chair, it is against this background that we welcome and support the introduction of legal requirements for wage gap disclosure and the disclosure of the salary of the lowest paid worker, as well as the binding vote on executive pay. Chair, as the committee would know, and members of the public would know, that in the year 1998, the TRC not only warned against the devastating impacts of inequality in our society, but clearly articulated the role of business in building a fair, inclusive, and a just society. This is according to the TRC, and I would like to read it in verbatim, Chair. The huge and widening gap between the rich and poor is a disturbing legacy of the past, which has not been reduced by the democratic process. It is morally reprehensible, politically dangerous, and economically unsound to allow this to continue. Business has a particularly significant role to play in this regard. Chair, the inequality which characterizes our South African society is widespread and multidimensional and poses arguably the country's biggest socio-economic challenge. And despite decades of recognition of this challenge, little progress has been made in addressing it since the end of apartheid, especially in the labor markets. Chair, according to Stats SA, exceptionally high levels of real earnings of high earners in this chart, it is depicted by the top line there, P99, together with low wages and negative real wage growth amongst the lower wage workers. At the bottom there, denoted by P10, the bottom 10%, and median earners are key drivers of high levels of inequality. This is according to Statistics South Africa. So contrary to popular belief, it's not just only unemployment that contributes to South Africa's status as having the highest inequality in the world. But further to drive the point home, Chair, this is also a slide by Stats SA. And according, this was based on the 2015 Living Conditions Survey. So it shows the income inequality in the labor market is the largest contributor to overall income inequality at 74.2% compared to other income sources. A year after this Living Conditions Survey was published, Bloomberg published this global CEO pay index. And according to this index, South Africa is the 7th best paid CEOs in the world. So the world's most unequal country. And with this inequality, which is largely driven by labor markets, as we've demonstrated in the previous slides, has the 7th best paid CEO in the whole world. Chair, for comparability, these figures are adjusted to take into account market capitalization of each country's primary equity index. So in our case, that will be the JSE top 40. For London, for instance, it will be the FTSE 100. So they are adjusted to take into account market capitalization. This is the argument that we are making, Chair. JSE has some of the best paid CEOs in the world. These figures are from the most recent company reports. That's 2022, 2023 remuneration reports, company reports. Chair, despite the low fixed investment in our economy, limited structural and racial transformation, and unsustainably high unemployment and inequality, the post-apartheid economy has generated extraordinarily high levels of corporate profits. And if you are looking at these figures, these nominal figures, you can tell that it's for the benefit of the few, for the arguments that will further advance below. And Chair, that it is within this context that we want to emphasize that there are vested interests, and we have to be really careful of the business lobby because of there are really vested interests. Chair, as you could see from the figures, the average actual remuneration awarded to CEOs in 2022 was 75.6 million. The lowest CEO earned 6.1 million, and the median was 58.4 million, and the highest earning was over 247 million. Chair, there are numerous arguments that are put forth, often without concrete evidence, to rationalize the high executive pay and to oppose pay gap disclosures we've heard from previous submissions, ranging from the ability to attract talent in this perceived global CEO market, and so on and so forth. These figures, Chair, we've just put these figures for comparison purposes. These are recent figures. These are not weighted. But if you were to compare these figures and factor in the cost of living within these due restrictions in Australia, in the UK, in Canada, in Germany, if you factor in the cost of living, or you compare these figures by looking at, sorry, so you are looking at them in relation to the cost of living, what you will find out is that SACEOs are better off. As I've mentioned before, we've recently published an investor briefing on vertical pay gaps on JSE-listed companies. As we know, Chair, that Principle 14 of the King 4 report on corporate governance, commonly referred to as the King Code, requires that remuneration policy to include provision for arrangement towards ensuring that the remuneration of executive management is fair and responsible in the context of overall employee remuneration in the organization. What we find out, Chair, is that JSE-listed companies invariably assert their commitment to fair and responsible remuneration in line with Principle 14 of the King Code. but often fail to support this assertion with evidence, such as pay gap disclosures or other relevant information. And secondly, the fairness of the lowest wages is typically assessed in relation to the national minimum wage, rather than the context of the organization's overall remuneration as mandated by King 4 or the King Code, or in comparison to a living wage. Chair, the lowest living wage is currently estimated to be between 8,000 to 9,000 per month for a full-time worker in South Africa, of course, depending on their area of residence, where they live. Chair, we've put in this slide, just for context, this is a methodology for estimating a living wage. It's called an anchor methodology. We are putting this one here because of it's the most cited, it is the one which is often cited by the ILO. So basically, it gives you a cost of basic by decent life for a given family size. As we've emphasized before, that it will vary from province to province in the context of South Africa. But this is what we are emphasizing. And Chair, these are vertical pay gaps at JSE listed companies. We've calculated this using the CEO's actual remuneration versus the lowest waging that were disclosed by these companies. So these are the only companies, based on our assessment, that have disclosed the wages of the lowest paid. And we've compared these, the CEO actual single figure remunerations with that of the lowest paid workers. And those are the pay ratios. As we could see, none of the retail sector lowest paid workers earned a living wage, Chair. We understand that while there is an important difference between sectors which impact level of pay, Just Share believes that stakeholders can make their own assessments on fairness on a case-by-case basis, and that this disclosure is a crucial first step in understanding and addressing the high labor market inequality that is so damaging to our economy and society. Chair, for reference, we just, because of Woolworths has recently published its remuneration, its reports now. For 2021, the pay ratio at Woolworths was 423. So the CEO was earning 423 times more than the lowest paid. And based on the 2022 CEO salary, which came from over 36 million to 122 million, that pay ratio is currently 1,269. This gives you the context of fairness within the overall context of overall employees within the organizations. So these pay ratios gives you that context as opposed to a claim. Furthermore, Chair, we've picked up various shortfalls with voluntary reporting. Since there's no prescribed method for the public disclosure of pay ratios in South Africa, companies are using a wide range of formats, ranging from the Palmer ratio, Gini coefficients, and so on, and different remuneration elements in their pay gap analysis. This makes the comparison relatively difficult. For example, some companies use CEO total guaranteed pay rather than the CEO total remuneration to calculate pay ratios. This obscures the fact that the major portion of executive remuneration, Chair, is derived from short-term and long-term incentives, or STIs and LTIs. Chair, some of the listed companies assessed in our briefing disclose their internal minimum wage. That is encouraging, but none of these companies explicitly states what is the lowest grade job that attracts this minimum salary. And no company refers to contract workers. But we want to submit, Chair, that pay gap disclosures are necessary and important as they provide crucial insights into the labor market inequality and steer informed conversations and a broader understanding of the state of pay disparities and the options available to reduce inequality and progress towards establishing a living wage for the lowest paid workers. So it's not an end, it's a means to an end. It's meant, so it's not like a magic wand because of publishing wage gap disclosures, you will reduce those ratios. No, they are meant to inform. So this idea that they won't make any difference is not here and there. It's unfounded because they truly inform. We therefore fully support, Chair, the rationale expressed in the background note to the current bill that the proposed publication of indicators of pay differential will empower shareholders and other stakeholders to see trends and, where warranted, provide proposed changes. So which means that shareholders now can also become actively involved as opposed to be passive participants. Chair, on our return submissions, we proposed the disclosure. We welcome the provision in section 30A, subsection 3, paragraph E of the bill requiring the disclosure of the remuneration of the lowest paid employees. We note, however, from the explanatory memo that a concern has been expressed to government that a potential consequence of the disclosure requirement may greater resort to outsourcing of the lowest paid employees simply to improve company ratios. So we propose, Chair, the disclosure should include the total remuneration of the lowest paid subcontracted workers who performs most of their work for or in the firm concerned or the company in questions, as well as the job title of that worker and the number of workers in that category of pay. And that the disclosure must also specify the job position or the title that represent the lowest grade eligible for a minimum wage within that company. Furthermore, Chair, I want to take just a few minutes on this one. We note with concern, Chair, that the bill does not propose disclosure of gender pay gaps. As part of employment equity reporting, designated employers, Chair, with 50 or more employees already provide information to the Department of Employment and Labor for the assessment of remuneration gap between the highest and the lowest paid employees, and to assess racial and gender inequalities across occupational level. Chair, however, this information is not publicly available. We also understand from the 2018 Presidential Job Summit Framework Agreement that there is inconsistency in measurement and calculation of pay disparities in terms of gender. So, Chair, currently what we have in front of us is the bill which addresses the issue of vertical wage gaps, but inexplicably neglects the gender dimension. And this is unfortunate, Chair, because according to the recent report of the Commission of Employment Equity, our labor market outcomes remain racialized and gendered. Furthermore, Chair, according to the Presidential Job Summit Framework Agreement, it emphasizes that gender parity is fundamental to whether and how economies and societies thrive, and addressing the issue of gender wage gap is a crucial issue to inclusion in the economy and drive transformation. This is very important, Chair, because women represent just over 46% of South Africa's economically active population, but according to Stats SA, women earn approximately 30% less than men. Furthermore, Chair, I want to submit that part of that agreement from the Job Summit, 2018 Job Summit, entailed the proposal for the implementation of pay transparency measures. So this includes gender wage gaps at company levels. And lastly, to this point, Chair, the idea of what we are proposing regarding the inclusion of gender wage gap, we believe that it aligns with one of the 3 policy objectives of the current bill as outlined in the background note and explanatory memorandum to the bill. And that objective, open quote, it says the achievement of equity as between directors and senior management on the other hand, and shareholders and workers on the other hand, as well as addressing public concerns regarding high levels of inequalities in society. So it will be crucial, Chair, to consider that inequality in our labor markets not only manifests itself through vertical wage gap, but also horizontal pay gaps. Our labor market outcomes are still gendered and racialized for that matter. Chair, for those reasons, we welcome the binding vote on remuneration policy and implementation reports. And Chair, the reason that we are saying that, we believe that the engagement process, which is required by the JSE's listing requirements, triggered when 25% or more shareholders vote against remuneration policy or its implementation report, is proven to be ineffective when it comes to ensuring that the remuneration of executive management is fair and responsible in the context of overall employee remuneration. Conclusion, Chair, we thank you very much for this opportunity to participate in this important process, and we strongly encourage the department and the committee to take into account the warnings of the TRC and all the detrimental effects of income inequality as they manifest in our labor markets, assessment of these submissions, as we try to forge forward, to move forward towards the realization of a more inclusive and a just society. Chair, this quote comes from Statistics South Africa's Inequality Trends Report. And Chair, if I may quickly read it in verbatim in closing, it says high levels of inequality mean that large segments of society may be excluded from economic opportunities, thus limiting both these individuals' outcomes as well as the aggregate performance of the economy. Such inequality of opportunity is not in line with the aspiration of post-apartheid South Africa as reflected in the Constitution and in the RDP, which has been the lodestar of all policy development since 1994. It reflects a loss of society of potential and productivity. People who receive the best opportunity are the ones who are the richest, and these are not necessarily the same as the ones who are the most talented or who would make the best use of such opportunities. Chair, I thank you very much for the opportunity. That is our verbal submission.
Thank you very much, Mr. Ngogela. I think you can stop sharing now, and then we'll open up to the committee to interact with your presentation. Committee members, I'll take hands. Can you stop sharing your screen, Mr. Ngogela?
Yes, Chair, that's I'm trying to navigate to that.
That's great. Thank you so much. Committee members, interaction with the report from Just Share. It seems that everyone is... Okay, there we have Honorable Mbuyane. Proceed, Honorable.
Yes, thank you very much, Chairperson. Let me first welcome the presentation by Just Share. It's more informative and it's eye-opening. I just wanted to check because you quote a lot of surveys and reports, starting from the labor market stats or the volume 5 of the TRC reports, 2015 living conditions. So I just wanted to ask a proposal, Norma, to say in terms of the bill, the company amendment bill, in terms of the view of the Just Share, are we in the right part in moving in terms of what we're doing, or there's a section that Just Share felt that we must be able to amend? But in terms of gender, wage, and also the disclosure, you made mention very clear, and we are fortunate to have such a presentation. Thank you very much, Chair.
Thank you. I think those were more comments, but I'll give you an opportunity to respond. Thank you, and close. Thank you.
Well, thank you very much, Honorable Mbuyane. We feel like we as Just Share, we support the provisions as outlined in the bill, particularly, Chair, the emphasis that we are making is that increased transparency will assist us as a society and business for that matter, to ensure that we forge towards a more living wage. And this argument about the attractiveness of South Africa as an investment destination, I feel like the business what they've been raising, I'm not here to respond to that. It's focused on shareholder returns as opposed to looking at the broader stakeholders and taking into cognizance broader societal interests. So we are encouraged that we are here, although we feel like this process is taking longer than it's supposed to, Chair, because we believe that these things should have been implemented long time ago. And part of the things that we are proposing anyway have been implemented in other jurisdictions. I mean, if you are having part of the developed OECD economies that have implemented binding a stronger say on vote to address the issue of skyrocketing executive remuneration in most cases, which is not even linked to company performance, and you compared it to us, we haven't done that, whereas we're the world's most unequal country. That is very dangerous, Chair, and I think maybe even business, they should contextualize investment attractiveness of our countries by factoring those things. And I don't believe a country which is riddled with poverty, with 50% of households coping under poverty, with such a high income inequality, if you do not factor those in your investment analysis, and I think that's just unfair, Chair. But overall, my last input will be that in South Africa, the issue of poverty is a serious one, and we are having a lot of women or female-headed households, Chair. And we know from the surveys by Stats SA, they have higher dependency ratio, which means if you do not tackle these gendered labor market outcomes, you are really not fighting poverty. So the issue of including gender wage gaps, obviously, which is not an end of itself, but there to inform such that companies can try to conduct this analysis annually and try to correct where they see there are unfair discrepancies or women are not getting a fair deal. So we strongly believe in this process, and we know that the business lobby will push strongly against some of the provisions there. It is expected, Chair. That's why we say just take into cognizance, and we know you are, that they are vested interests. With that, I'll thank you very much, Chair. Thank you very much.
Thank you very much for your presentation and your responses. It has assisted the committee. We now move to our last presentation for the day, which is from Amabungani, and it is led by Ms. Caroline James. You may proceed and share your presentation.
Thank you very much, Madam Chair. I will share my presentation now. Is it visible?
Yes, it is. Thank you so much. Proceed.
Great. Thank you so much. I would just like to thank you for this opportunity to make this presentation. And what we will be doing is highlighting sort of two main problems that we see in the broad framework that this bill doesn't completely amend and resolve the problems in this framework around, particularly, and our focus here is on maintenance of and access to beneficial ownership information. So our concerns are around that the framework doesn't create the systems where this information can be collected and maintained. And then the secondary problem with that is that there's insufficient access, which is given to the public to access that company information. And our concern with that is that that is where a lot of the oversight into company conduct and irregular financial crimes within companies occurs. I think I really do need to emphasize that this question about beneficial ownership is not only one that we have, and it isn't purely because of our interests in transparency around beneficial ownership in companies as we've experienced through our investigations, but it's a much broader concern for the country, and this is why we think that the bill's lack of creating sort of strong systems is so problematic. And this is because of the FATF findings that led to South Africa being grey listed as a country, which will have significant impacts. So one of the findings that FATF, which is the Financial Action Task Force, found is that the South African authorities are yet to put in place policies to tackle the challenges in accessing accurate and up-to-date information on beneficial owners of legal persons and trusts. One of the priority actions that FATF mentioned in its mutual evaluation report, which is the report into South Africa's ability to combat money laundering and terrorist financing, is that one thing South Africa must do is establish these better mechanisms to collect beneficial information. And if we are not able to show by the time we have a review process with FATF that we have got this mechanism to collect this beneficial ownership information, it is highly unlikely that we will be able to move off the FATF grey list. And as was discussed in the media and by the President and National Treasury, is that there are significant economic downsides to remaining on the grey list. The most recent and most sort of solid study into the actual economic impact is a recent IMF study, which says that there is an average decline in capital flows of 7.6% of a country's GDP once they are grey listed. So when we look in the broader picture, it is vitally important that we take all the measures that we've committed to ensure that we move off this grey list. In the bill, and this reflects the sort of the problem within the broader framework, is that there's two different concepts, but they seem similar, and in some situations they are used interchangeably, but they are very distinct, and that is between beneficial ownership and beneficial interest. And although both of them attempt to, as the sort of the technical term is, to pierce the corporate ownership veil, it is only beneficial ownership that really does this. And this is because beneficial interest, the definition of it includes a natural or juristic person, and it only relates to someone having a right or entitlement to their interest in the company. Whereas beneficial ownership relates only to a natural person, and the definition involves a natural person who ultimately owns and benefits from the company. So the purpose of beneficial ownership is that the idea is that then you are able to track the chain of ownership to the ultimate natural owner. And it is only the use of beneficial ownership that will enable this. So our suggestion and our solution to this problem, and as I've highlighted, it's a problem that FATF has also identified, is that throughout the Companies Act and the possibility that this bill has is to change the concept of beneficial interest, wherever it is mentioned, to be replaced with beneficial ownership in the Act. One of the problems that we found, and I think part of the difficulty that we've identified, is that there may well have been the intention behind companies or the drafters of the law to adopt this beneficial ownership disclosure obligations, but there's been some sort of incorrect drafting, and perhaps just because there was such a short time to try and amend the FATF guidelines, there's been some difficulty that's come up in the drafting. But one of the problems that we've identified is that there are three categories of companies within the framework. So there are public affected companies, other affected companies, and then non-affected companies. And the problem with this is that affected and non-affected companies are treated differently within the legislative framework. And then even within affected companies, public companies are treated differently from non-public companies. This is particularly notable because there is a separate definition for public companies. Non-affected companies have the most solid obligations around beneficial ownership. So Section 53A of the Act does require that non-affected companies record their beneficial owners in the securities register. And this is exactly what needs to occur in the Act. It's clear, it's ownership, and it's beneficial ownership as well as the recording of this information. But the problem comes in is with the regulations, because the regulation that gives effect to this legislative provision refers to beneficial interest. So although in the regulation there is a mention of beneficial owner, the strange drafting of it means that it's still conditional on beneficial interest. And we do go into the text and the wording of this more deeply in our written submissions, which you all would be able to refer to. There's also an obligation on non-affected companies to file a record of their beneficial ownership. Again, it's ownership, not interest, which is very positive with the CIPC. But the problem then is there's nothing that allows the companies to learn about the beneficial ownership. There's no obligation on members of the company or shareholders to disclose that ownership to the company, and then it's impossible then for the company to adhere to this obligation that the Act creates, because there's nothing, they just don't have the mechanisms to be able to provide that. So in respect of non-affected companies, in summary, what it is that there's an obligation to record the beneficial ownership, but in practice, those companies simply cannot get that information. And then the regulations contradict the law by conditioning the recording of beneficial ownership on the existence of a beneficial interest in the company. If we move on to affected companies, then I'll first look at public companies. So here, this is the only obligation that is placed on shareholders in companies within the legislative framework. So shareholders in a public company have an obligation to disclose to that company if they are not the only person who has a beneficial interest in the securities held by them. And this is a very positive obligation placed on shareholders. And this is one of the mechanisms by which companies can learn about the beneficial interest, or ideally beneficial ownership, that shareholders represent. So again, we welcome the fact that there's an obligatory disclosure on the shareholders, but feel that it's very important that this is for beneficial ownership rather than for beneficial interest. All companies are treated the same in only one way within the legislative framework. And this gives companies the right to request from shareholders that they confirm or deny whether they are holding a security for the beneficial interest of another person. The difficulty with this is that it's only a right. Companies are not obliged to learn this information from shareholders. And in addition, the right is limited because they are only entitled to do so when they have a reasonable belief that the shareholder is holding the security for someone else. And then there is no obligation, even if they do have that reasonable belief. There is, within affected companies, there is an obligation on those companies to establish and maintain a register of beneficial interest. But again, that there are different obligations on public and non-public affected companies, which complicates the system and makes it difficult to understand exactly the obligations companies face. I'll skip over this in the interest of time, but all the details around the sections are clearly made in our written submissions. I think the key thing that I would just like to highlight is here there is an introduction of a level of beneficial interest that is missing in other parts of the legislative framework, which again adds another layer of complexity to it, where it would be far easier if there was just one clear standard rather than additional levels of obligation. And this is when people hold beneficial interests equal to or in excess of 5% of the total number of securities. So again, it's now requiring additional calculations from companies, which adds to the difficulty in learning what they are supposed to be doing. So to summarize, our main problem with the legislative framework and the way that the bill fails to amend this is that in respect of beneficial ownership, there is only an obligation on non-affected companies to establish and maintain a register. No other type of company has that obligation. But then more importantly, in practice, even those non-affected companies are not able to obtain that information. And so the crux of this is that our legal framework that is established within the Companies Act, and then the General Laws Amendment Act that was passed last year, and then these bills will simply not address beneficial ownership. And so will simply not respond to FATF's concerns and will hinder our ability to move off the grey list. Our final comments on these bills relates directly to our interest in accessing information, but it's an interest that should be shared by the public and by other members of the media and civil society. And this is to ensure that the legal framework is clear and unambiguous in providing access for public to that company information. This must include the beneficial ownership registers. And I note that some of the previous speakers mentioned concerns over privacy of personal information, but I think it's very important to note that there is no limit within the Protection of Personal Information Act that will prevent this specific information being disclosed. And there is always the opportunity to redact highly personal information, perhaps like a cell phone number and other information that would classify as personal information. So there should not be a concern around the broad protection of personal information as a way to prevent this disclosure. And in any event, there are international examples of this happening, and within the FATF structure, this is required and it's demonstrably beneficial. The problem that we see in this direct access is again linked to the broader and fundamental problem that it relates to beneficial interest and not beneficial ownership. So although Section 26 does provide access to the Register of Disclosure of Beneficial Interest, it will not meet the high standards of FATF and what should be provided in broad transparency principles, that it's access to beneficial ownership. And again, the solution here is simply to remove the distinction between beneficial ownership and interest, and then also remove the distinctions around the reporting obligations of the different categories of companies. This, again, I see I am running out of time, but this Section 2A is also problematic within Section 26 because it introduces different categories and different standards for disclosure to the CIPC. It is more detailed in our written submissions. And again, here, although the CIPC is obliged to make information available electronically, the difficulty comes in because of those different standards that the different categories of companies have, which means that the public trying to access information through the CIPC will have differing access depending on the type of company they are trying to obtain information on. Again, the same solution is to remove the distinction between beneficial ownership and interest, and then the different reporting obligations. The final point that I have to make, and this is a very small point, is that one of the requirements that FATF has around access to beneficial ownership information is that it's up to date. And at present, the information and the obligations on CIPC and the companies require an annual disclosure. Even though companies have certain time restrictions or time deadlines to make disclosures of beneficial interest to the CIPC within 10 days or 90 days of obtaining that information from their shareholders. We would then propose that to ensure compliance with the FATF standards is that there's a requirement, then CIPC then updates their access to information on that real time. We recognize that Straight is also disclosing company information, but we would also just recommend that be legislatively confirmed within the legislation. So it's not dependent on a decision from Straight whether or not to disclose that information. That is my presentation, and I'm happy to take comments, but again, I would refer you to the written submissions for greater detail on our points.
Thank you very much. Members, there's the presentation from Amabungani. Can I have hands for interaction with this presentation? I see I am unmuted. I thought I'm muted. Okay, the Honourable Thring.
Chair, thank you. Chair, just one question. Ms. James indicates that, and firstly, thank you for a presentation. I think it's very different from most of our other presentations, and comes with another angle, and I think investigative journalists flair also coming through in terms of what their concerns are. But just the one question, you've indicated that the bill does not address the beneficial ownership for affected companies, and neither does it meet the needs of FATF, and hence our grey listing. Now, how do you balance that against, and so you're making the recommendations that your affected companies with regards to beneficial ownership should also be included. Now, how do you balance that against what some of the other concern groups spoke of, is with regards to criminality, where there is this information that becomes accessible to different groups? So that's my question, Chair. It's a question of criminality as opposed to making the information available, particularly with regards to your beneficial ownership. Thank you, Chair.
Thank you. It seems that is the only question. Ms. James, you can proceed.
Thank you very much. Thank you, Honourable Member. And thank you for the engagement with the topic, because as you say, it is quite different to some of the other issues that have been raised. But for us, we do believe it is a vitally important aspect of this bill and the legislative framework that it seeks to amend. I think my way to respond to that would be to highlight the reasons for FATF requiring these types of disclosures, and that the whole purpose behind FATF and the suggestions and recommendations that they make to countries is underpinned by the desire to combat money laundering as well as terrorist financing. And so the goal behind having this disclosure of beneficial ownership is to combat criminal activity. It is a specific type of criminal activity that it's seeking to combat, but it's an incredibly important and incredibly widespread criminal activity. And not to sort of toot our own horns, but if you've seen some of our recent articles that we've been publishing, we've demonstrated how prevalent money laundering is in South Africa, but also in the region, and how imperative it is for our economy that this be combated. And it's our belief, and it is demonstrated in the case studies that FATF has shown, and their experience of identifying what is a solution to this type of money laundering. And that recommendation really is to ensure that individuals cannot use corporate structures to hide and to use those corporate structures in an abusive way to facilitate money laundering and other financial crime. And I think this transparency around who is the ultimate owner of companies would go a long way to combating that type of abuse of the corporate structure. I do completely understand that in a country like South Africa, where there are high levels of all sorts of crime beyond just financial crime and this specific crimes of money laundering and terrorist financing, there are other concerns. But we do believe that there would be ways to balance those concerns, whether it is around certain redacting of information, or improving reporting abilities of companies that may be at risk of other types of criminality, and sort of reordering the system around that to accommodate these two. But it is our belief that this type of crime can only be solved through this disclosure of beneficial ownership information, and so that must also take precedence.
Thank you very much. That concludes our presentations for today. So thank you to Abba Bungani for closing out our public hearings for today. To all the stakeholders who have presented today, we will be deliberated on all the presentations received over the 3 days. We will conclude on Friday. And then next week, we will be deliberating on all these inputs, including your written submissions. So thank you very much for your inputs today. Committee Secretary, can I just check if there is any announcements before we close?
Chair, just to indicate that we'll conclude, as you indicated, our public hearings on Friday, Chair, from starting at 9 until 1 o'clock on Friday. And we will communicate the presentations. We will forward it to members hopefully by tomorrow when we receive all of them. Chair, thanks.
Thank you so much. The meeting stands adjourned. Thank you.
Thank you, Chair.
Long live Chair. Long live Chair.
Long live the Chair.
Recording stopped.